Today, we will discuss the concept of pass-through entity taxation within the context of the Federal Internal Revenue Code and small business owners. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the great states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my law practice. Our firm website is www.cummings.law. First, let's start with some basic terminology. What is pass-through taxation? Pass-through taxation is a tax mechanism that allows business income to be taxed at the individual owner's personal tax rate rather than at the entity level. This taxation structure is notably beneficial for many, but not all, small and medium-sized business owners seeking to avoid the punitive double taxation that corporations usually face when they are taxed under Subchapter C of the Federal Internal Revenue Code. In essence, business profits and losses pass through to the owners, who may be individuals, trusts, other partnerships, corporations, and so forth, who then report this income on their individual tax returns. This approach is primarily applicable to business structures such as partnerships, Subchapter S entities, and certain limited liability companies. It is also important to note that sole proprietorships are also treated as pass-through entities. Actually, we typically refer to those as being a disregarded entity when it is taxed as a single member LLC, but I digress. We'll save that for another presentation. The primary advantage of pass-through taxation is its simplicity and relative efficiency in terms of tax filing. Business owners should, however, be aware of the many implications of this method of taxation, as it can significantly affect their personal tax burdens. Sole proprietorships are the simplest form of pass-through entities where the business is not legally separate from the owner. This means all income and expenses are reported directly on the owner's personal tax return, Schedule C 1040. This structure is straightforward but does not offer liability protection, and therefore we never recommend it to our clients. Partnerships, including general partnerships, limited liability partnerships, and even limited liability limited partnerships, also benefit from pass-through taxation. In these structures, income is distributed amongst the partners based on their profits percentage, and each partner includes their share on their respective tax return. S corporations, so named because they are taxed under Subchapter S of the Federal Internal Revenue Code, as well as certain types of limited liability companies or LLCs electing to be treated as pass-through entities, may also use pass-through taxation. The IRS limits the number of shareholders in a Subchapter S entity, and they must adhere to very specific, very strict eligibility criteria. One of the most significant advantages of pass-through taxation generally is the avoidance of double taxation, which Subchapter C corporations encounter, whereby income is taxed at both the corporate level as well as at the shareholder level. By allowing income to be taxed only at the individual level as opposed to at both the entity and individual levels, business owners using a pass-through structure can potentially save a substantial amount in taxes, although that is not always the case. Additionally, pass-through taxation generally simplifies tax reporting and compliance, although there are certainly some notable exceptions. Business owners report income and losses on their personal returns, reducing the need for a separate corporate tax filing, though federal Form 1065 must also be filed for entities taxed as a partnership and Form 1120S for Subchapter S entities. This not only cuts down on the administrative burden as compared with utilizing Form 1120, but also decreases the likelihood of errors in tax calculations when working with an experienced CPA. Moreover, pass-through entities may be able to take advantage of the so-called qualified business income or QBI deduction introduced under the Tax Cuts and Jobs Act under the prior Trump administration. This deduction allows eligible business owners to deduct up to 20% of their qualified business income, which is a term of art, thereby potentially providing a significant tax benefit. For more insight into the QBI deduction or any of the other topics we have covered, I encourage you to visit the IRS website at www.irs.gov or schedule a consultation to speak with me. While pass-through taxation offers numerous benefits, it also presents certain challenges. The primary concern is the potential for higher personal tax rates. Since the business income is reported on the owner's personal tax return, it can push the owner into a higher tax bracket, increasing their overall tax liability. It is also important to note that under this structure, the owners may be liable for the so-called self-employment tax, although that merits a separate conversation and is somewhat beyond the scope of today's presentation. Moreover, pass-through taxation requires meticulous record keeping and accounting, although the same can be said for virtually any business structure. Business owners must ensure consistent and accurate reporting of income or expenses to avoid potential discrepancies that could lead to audits, interest, and penalties. This necessitates a robust accounting system and often the experience of a qualified CPA or tax attorney. Finally, the eligibility criteria for certain pass-through entities, particularly Subchapter S entities, can be quite restrictive. Business owners must carefully evaluate their business structure and growth plans to ensure compliance with all IRS Treasury regulations to maintain their pass-through status. Choosing between pass-through and entity-level taxation requires a thorough analysis of the business structure, income levels, growth projections, and long-term goals. Pass-through taxation is generally, but not always, advantageous for businesses with lower income levels or those seeking relative simplicity in tax filings and compliance obligations. However, owners of larger businesses or those considering reinvestment of profits into the business may find corporate taxation more beneficial. Subchapter C corporations can retain earnings within the company to fund growth initiatives without immediately incurring personal tax liabilities for the owners. Therefore, it is strongly advisable for business principals to consult with their tax professionals to weigh the relative pros and cons specific to their financial situation and business objectives. Ultimately, the decision hinges upon a balance between minimizing tax liability legally and ethically and achieving operational day-to-day efficiency. Again, my name is Chad Cummings, and I hope that you found the information in this presentation helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding the information of this presentation or of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.